So we need to talk about a new case that was granted review by the Supreme Court and is now set to be heard by them on October 15th. This case attempts to build upon a prior 9-0 unanimous decision by the Supreme Court, which prevents the unlawful search and seizure of firearms within your home without a warrant. So let's break down what is happening in this critical challenge. Now, before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. You guys know that 1st Phorm's an amazing company. They have great supplements. I highly recommend their protein powder. The Formula 1 mint chip is my favorite. I also really enjoy their pre-workout. But one of the really cool things about 1st Phorm is their pro-freedom, pro-America, and their culture is unmatched. It bleeds into everything that they do. And if you've ever, encountered any of their employees or any of the people that follow 1st Phorm, you know that culture and American values and hard work is, first and foremost for what they do. So if you're interested, check out 1st Phorm using the links down below in the details section in the pinned comment. And if you order something $100 or more, you will get free shipping with my link and also 30 days to get your money back if you don't enjoy what you order. Now, as I mentioned in the intro, in this video, we're going to be discussing a new Supreme Court case that was granted review, and this involves when police officers can enter someone's home without a warrant. This case tries to use and build upon a prior 9-0 unanimous decision by the Supreme Court, and this all involves the warrantless search and seizure of firearms within a home. The new challenge pending in front of the Supreme Court, which was granted review and is going to be argued in October, is a case called Case versus Montana. This new challenge is important for gun owners to understand because it involves when law enforcement officers can use legal workarounds to not only enter your home without a warrant, but also potentially confiscate guns without a warrant. This case is now set for oral arguments on October 15th, and recently you had organizations like Gun Owners of America and other groups jump in, file amicus briefs in support of the plaintiff here against the state of Montana. And also you had all of these now recently be circulated to the Supreme Court for their consideration and review before those oral arguments. Now, the facts surrounding this specific challenge are very interesting. Essentially, in this lawsuit, it results from an individual, Mr. Trevor Case, and he had an ex-girlfriend who called police on essentially him, saying that he had threatened to harm himself and that he also might have a gun. She also told the police officers that Mr. Case had told her during the call that if police officers showed up, that maybe they would get harmed. And apparently, there was prior interactions between law enforcement and Mr. Case. They knew him, they had had interactions with him, and they also knew that he potentially had a history of mental health issues. When the 4 police officers arrived at the home, they kind of looked around, they looked through some open windows, they shined lights into some of the windows. They did not see Mr. Case. One of the police officers said that she noticed an empty handgun that was in a holster and a notepad. The police officers tried to call for him. They, called through some of the open windows. They knocked on the door. And eventually they decided that, they were going to enter the home through the front door, which was unlocked. They sat outside the home for about 40 minutes, and then they made that decision to decide to enter the home. Now, many of the police officers on the scene expressed concerns about entering the home because of prior interactions they had with Mr. Case and also the threats that were conveyed to them on the phone call. There was also a short discussion about maybe calling his father to come to the house, try to get into the home, tried to make contact with Mr. Case. And they also, talked about maybe just trying to call Mr. Case on his cell phone. But ultimately, the police officer decided to do none of that. Instead, they entered through the unlocked front door after 40 minutes. Now, when the 4 police officers entered the home, 2 of the police officers went upstairs, and one of the officers entered an upstairs bedroom. And in that bedroom, he saw a closet curtain, in his words, jerk open, revealing Mr. Case's face, and he said he saw something which appeared to be a black object. Now, in response to that, the police officer shot Mr. Case once in the arm and then once in the stomach, and then after that, he got medical attention, and eventually they recovered a handgun in a laundry basket, which was claimed to be near Mr. Case. Now, in response to this, Mr. Case was charged with some, criminal violations, and he argued that the officer's warrantless entry into his home violated the 4th Amendment, so the gun and other evidence that was found at his home should be suppressed. Those arguments were ultimately rejected by the lower court and eventually also rejected by the Montana Supreme Court after a 4-3 split decision. This challenge has now made its way to the United States Supreme Court and has now been granted review, and they're going to hear oral arguments in this case on October 15th. Now, the question presented for the Supreme Court to decide is whether law enforcement may enter a home without a search warrant based on less than probable cause that an emergency is occurring, or whether the emergency aid exception requires probable cause. In his petition to the Supreme Court, Mr. Case argues that while this court has recognized exceptions to the exigent circumstances requirement, it has jealously and carefully drawn those exceptions. The court should take the same approach in defining the exigency exceptions to the emergency aid exception and hold that officials must have probable cause to believe an emergency existed before making a warrantless home entry. He then goes on to argue that the Montana Supreme Court upheld the officer's warrantless entry into his home on the basis of a community caretaking test requiring only reasonable suspicion of an emergency. He states that that decision not only contravenes Caniglia, but more fundamentally adopts a less stringent standard of knowledge. Now, if you're not aware of what happened in Caniglia and why that's important and why Mr. Case is using that and trying to expand upon that, essentially, in that situation, a husband and his wife got into an argument one night, and during the argument, the husband got out a handgun, put it on the table, and told his wife, well, why don't you just take it and put me out of my misery? The wife, in response to that, of course, was concerned, so she left the home and decided to stay at a hotel overnight. The next morning, she tried to make contact with her husband. She tried calling him. He didn't answer, so she decided to call police. Now, after that, the wife and the police officers arrived at the home. They found Mr. Caniglia on his front porch. Nothing was wrong. The police officers were concerned about him, so they decided to take him to the hospital for a psychiatric evaluation. But before they did that, they had a conversation with Mr. Caniglia, and they told him that, they weren't going to take his firearms. He expressed to them that no, he did not consent to them taking his firearms or confiscating them, and they said that they would not. Now, after he left for the hospital, they then had conversations with the wife, and they told her that the husband had actually consented to them confiscating those firearms and taking them out of the home. Now, she believed the police officers. She assumed that they were telling her the truth, so she let them into the home, and they took all the handguns and the rifles out of the home. Now, this case eventually made its way to the Supreme Court back in 2021, and on review, the Supreme Court issued a rare 9-0 unanimous ruling in favor of Mr. Caniglia. The Supreme Court struck down the whole community caretaking rationale that was used to enter the home and take the guns. Now, since that decision, the Supreme Court has not considered the circumstances of when police may enter a home, essentially since 2021. They had an opportunity to also look at some things about red flag laws, using Caniglia after the fact, but they denied review to all of those situations and all those cases. It is that ruling in Caniglia that the Case versus Montana challenge now seeks to expand upon. Recently, amicus briefs were submitted in support of Mr. Case by two-way organizations like Gun Owners of America. They state that reasonable suspicion is not the standard, probable cause is the standard, and the ruling down below by the Montana Supreme Court must be reversed. So now you have multiple two-way organizations jumping in this challenge in support of Mr. Case, and they're pushing the Supreme Court to rule in favor of Mr. Case. This is important because it impacts everyone's protections against these types of warrant exceptions. The Supreme Court now has an opportunity to clarify or expand upon that prior 9-0 unanimous ruling in Caniglia, which can have the direct downstream implications on what protections we all have from police officers and the government at large, essentially from entering our homes under the warrantless search and seizure, exceptions, and what type of restraints should be put on those exceptions. Like I mentioned, the oral arguments are currently set to happen on October 15th, so the Supreme Court really soon, in just a month, are going to get together, hear those oral arguments for Mr. Case in the state of Montana there, and it's going to be interesting to see how this develops. And now we're going to be anticipating what happens during those arguments, and you can kind of gather a lot from those oral arguments and get a good feel about how the Supreme Court is going to lean on this issue. But generally, the Supreme Court has been very wary and has struck down a lot of exceptions to the Fourth Amendment's warrant requirements, especially when it comes to the home. Recently, the Supreme Court has been very active, over the last decade or so, cutting out those exceptions and saying that there are not as, broad of exceptions as police officers claim there are. So again, a critical challenge, a critical lawsuit and oral arguments that are now going to happen on October 15th. As we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, armscholar.com. Over there, we have a lot for you guys, channel merch, deals and coupons, but also you can find the free legal guide that we have for you guys. All you have to do is put in your email. We email you over a free PDF with some legal information. It's just educational information, but also we do some follow-up emails with additional educational information and then some daily deals and things like that to save you some money. But as always, thank you guys so much for all of your support. But never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.